The next matter to come before us this morning is Harrell, further known as Donovan, versus Michael Donovan. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and wish to reserve any time, if you let me know when you get started, I'm keeping the clock and I can keep you apprised of the passage of time. You each have 15 minutes to present oral argument this morning. Sorry, I apologize if I already said that. We've read the briefs and we're ready to see who you are. The appellant, correctly? Is that correct? If you would use this podium, you will have 15 minutes to argue this morning.
Thank you. Good morning, Your Honors. My name is Heather Harrell, and I just wish to ask the court for an extension to obtain counsel due to the fact that I became aware of the hearing today. I received a notice, but it was addressed to me, but for somebody else's hearing, so I had no knowledge of what was going to happen today. So I wish just to have time to obtain counsel.
And we had not received any motions to continue prior to today's scheduled oral argument. And I do understand that you are pro se this morning. But we have set this time this morning for oral argument. So if you would like to present any oral argument, and you have a brief that's been filed, but if you would like to present any oral argument today, now would be the time to do so as well.
I really don't have much knowledge.
Okay. Thank you.
Good morning, Your Honors. Briefly, as it relates to this matter, I would just address a handful of points rather quickly and then stand on what I filed with in my brief. As the court is well aware, there was no transcript ever filed in the lower court to proceed with the objection hearing in violation of Civil Rule 53, and no transcript filed in this particular case. Briefly on the change of circumstance argument, this court, at least about a year ago in Perkle v. Perkle, decided on September 30th, 2014, that Bratz was still the controlling law from the Ohio Supreme Court, and also indicated there's a distinction between 3109.051, the visitation requirements, and 3109.04, custody requirements. Also, cert was denied on the Perkle case at 429.15. I believe this court needs to stand on the law that it has previously decided in that particular issue, as they are distinct legal concepts as pointed out by this court. As far as the other argument of the appellant, if the court would take full judicial notice of the docket sheet, the appellant was relieved of any liability in the Comstar case. Her own previous lawyer, John Rosenbaum, had filed a motion. I cited what page it was on. The next page, about a month later, it was decided between the parties that Heather Donovan would be relieved from any liability in that civil suit, and the court agreed with that. She was never garnished, never proved, and she cannot support to this court that she was in any way, manner whatsoever economically harmed, because there's been no transcript that's been submitted. So, as I said in the lower court, if the court wants to take judicial notice of the docket sheet, then please take judicial notice of the entire docket sheet. I think both these arguments are without merit, and I would ask that you sustain the judgment on the objection in the lower court. Thank you for your time.
Thank you both. The court will take the matter under advisement and issue a written decision which we know to both sides, as well as posted on our website and the Supreme Court website.
Thank you, Your Honor, for your time.